All right, court will make a referral to the public defender's office, enter a not guilty plea on your behalf, and set the matter for a pretrial. That is where your attorney and an attorney from the prosecutor's office will have a meeting to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, a $500 bond was posted over the weekend. Historically, I show an 02 operating while intoxicated third, 04 failed to pay child support, 2 counts of that, 06 driving the license suspended second, 08 resist and obstruct, 10 a domestic violence, 10 a resist and obstruct and OWI, 16 a resist, 2 resist and obstructs, 19 an assault and battery, jostling and disturbing the peace. On the local record in 17, there was an allowing an unlicensed driver. In 1990, a disorderly, 94 an OUIL, 94 driving the license suspended, 98 an OUIL, 98 driving the license suspended, and 98 disorderly. Any comment regarding bond from the defender's office?
Your Honor, I'd ask that bond be continued as and I would I have no problem with no contact order. I didn't give quite as long a thought to Mr. Drowdry as I would have liked, so I don't have very much information, but
Thank you, prosecutor's office.
Thank you, Your Honor. I'd ask for a no contact order with the victim, Emily Bartholomew. Anything else in court discussion?
All right, the court will continue the bond as previously set. I'm going to order that you appear as ordered to keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not have any contact with Emily Bartholomew. No contact means no contact at all, not by phone, text, email, social media, or anybody acting on your behalf. If you are found to be in violation of your bond, you could be arrested without a warrant, brought back to jail, and have your bond revoked. You understand that?
Yes.
Okay. I'll need you to go out to the front window where you checked in and get your next court date. Okay, thank you. Person at the jail, what is your name?
Darryl Pruitt.
Mr. Pruitt. I have a few files for you. The first one is case number 252722FY, the people of the state of Michigan versus Darryl Pruitt Jr. In that case, I have a probation violation that alleges non-technical violations of new criminal behavior, possession of methamphetamine second or subsequent offense, controlled substance delivery manufacturing methamphetamine second or subsequent offense, controlled substance delivery manufacture of a narcotic less than 50 grams, second or subsequent offense, controlled substance possession of narcotic less than 25 grams, as reported by the Wexford County Sheriff's Department on August 31st, 2025. If you are found to be in violation of your probation, you could be sentenced to what you could have been sentenced to under the underlying charge of use of methamphetamine, which is a 1-year misdemeanor. Then in case number 25373SM, it is alleged that you are facing the same probation violations. If you are found to be in violation of that probation, you could be sentenced to what you could have been sentenced to under the underlying offense of domestic violence. That is a 93-day misdemeanor. Then in case number 253913FY, we are here for a new case, and that case alleges that on or about August 31st, 2025, in Herring Township of Wexford County, that you did in count number 1, possess the controlled substance methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. The prosecution has charged you as a second subsequent offender, which means that you have at least one prior drug conviction in your past. That makes that 10-year felony a 20-year felony, and the $15,000 a $30,000. In count number 2, it is alleged that you committed the offense of delivery or manufacture methamphetamine. That is a the original charge is missing from the complaint, but I believe that's a 20-year felony. They have also elected in that one to charge you as a second subsequent offender, which makes that 20-year felony a 40-year felony and a fine of up to $50,000. In count number 3, it is alleged that you committed the offense of delivery or manufacture of cocaine, heroin, or another narcotic, in this case, fentanyl, in an amount less than 50 grams. That is a 20-year felony and or a fine of $25,000, and a consecutive sentence may be imposed if it happened in the place of imposed for any other felony conviction. Additionally, they've elected to charge you as a second offender in that one as well, which makes that 20-year felony a 40-year felony and the $25,000 $50,000. In count number 4, it is alleged that you committed the offense of possession of cocaine, heroin, or another narcotic in an amount less than 25 grams, in this case, fentanyl. That is a felony punishable by up to 4 years and or a fine of $25,000. Additionally, they have elected to charge you as a second offender in that case as well, which makes that 4-year felony an 8-year felony and the $25,000 a $50,000 fine. Do you understand those charges and the potential penalties?
Yes.
Sir, is the contact information you gave to Community Corrections, your phone number, your address, and your email, is that all accurate?
Yes, sir.
Did you have the opportunity to meet with somebody from the defender's office today?
This morning I did.
All right.
This
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to be represented by an attorney. And if you could not afford one would be appointed to represent you at public expense. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions at any time. Do you understand those rights?
Yes.
Today, do you plan to, I'm going to jump around a little bit. In your probation violation files, you also have the right to have an attorney in those files as well, and to have a contested hearing in that matter where the prosecution must prove those allegations. For all of these cases today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I'm going to have to request one, please.
What is your current source of income?
I'm just doing odd jobs of landscaping right now.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. We'll enter not guilty pleas in all of these files. We'll set the probation violations for contested hearings, and we'll set the new felony file for preliminary examination. That's a hearing that's held here in the district court within 21 days. And at that hearing, the prosecution must prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the crimes. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, you'd be ordered to stand trial in circuit court. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, historically, I show in 03 an aggravated assault, in 10 a driving while license suspended, in 23 a disturbing the peace, in 07 there was a 4A case, in 25 there was a domestic, in 25 a use of meth, and he is currently on, as we've said, probation in a couple other cases. The praxis scores him at a risk level 4, so medium risk. Bond was previously set at $100,000 over the weekend. Any comment regarding bond from the defender's office?
Yes, Your Honor. It is my understanding, or at least it's been reported to me by the defendant, that he is been compliant with probation conditions up to this point. I would ask, he lives in the area, given that it's my understanding he's been compliant with probation. I believe that as we continue further, this is going to be a case where some of these charges are dropped due to the codefendant that was named earlier. That being said, I would request a personal recognizance bond or a low cash bond. Although I respect that he may be remanded on the other cases, in which case I would not want the personal recognizance bond. Thank you.
Thank you. Ms. Carey?
Thank you. The people do not believe this is appropriate for a PR bond. He is the co-defendant with Mr. Couples Yeah, and in the trunk of the vehicle that he was the driver in was the 220 grams of methamphetamine and 26 grams of fentanyl. And along with that, there were some scales and there were 2 scales of the vehicle combined. Given his history, in speaking briefly with Ms. Bismack, he has not been compliant on bond. He has passed the test, but he's not engaged in counseling or provided verification of that. So frankly, I again, I appreciate the bond was set at $100,000 over the weekend, and I would ask the court to consider increasing that. Thank you.
Thank you. When I review the praxis, it indicates that the defendant was a failed to appear one time, does not appear to have stable housing, and states that he does have an issue with methamphetamine. Given the allegations as presented, I do show that I believe the defendant is a threat to the community of that amount of methamphetamine and fentanyl. I also find that he is a flight risk as well. I will keep bond at the $100,000 as previously set with the following conditions: that he appear as ordered, keep his contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that the defendant not consume any illegal controlled substances, including recreational marijuana, and that he be subject to random testing. And that he be, if he does bond out, be placed on a GPS tether for location purposes only. In the probation violation files, he'll be remanded until we have the hearing. Next arraignment.
All right, let's talk about that. This arraignment in front of Judge Corey J. Wiggins was a heavy one, both in terms of the charges on the table and the defendant's history. The defendant, Darryl Pruitt Jr., walked into court already facing probation violations, and by the time the new file was read, the list of charges sounded more like a small novel. Judge Wiggins, as usual, was calm, professional, and methodical. He didn't rush a word, making sure every count and potential penalty was crystal clear. Himself kept his demeanor subdued and respectful. He answered clearly, admitted he'd need a court-appointed attorney, and even described doing odd jobs of landscaping when asked about his income. But there was no denying the weight of the moment. When Wiggins read out the allegations, possession of meth, manufacturing meth, possession and delivery of fentanyl, the potential maximums doubled with second offender enhancements, turning 10 and 20-year felonies into 20 and 40-year ones. You could absorbing it all quietly without protest. His body language was more resigned than defensive, the look of someone who's been in this seat before. The defense did what they could. Counsel noted that Pruitt lived in the area, had been complying with some aspects of probation, and argued for a personal recognizance bond, or at least something lower than the $100,000 already set over the weekend. It was a respectful but uphill argument, especially given the severity of the charges and the codefendant link to a vehicle containing over 200 grams of meth and fentanyl. Counsel even conceded they expected some charges might get dropped as the case developed, but the plea for leniency was more about keeping the door open than a confident push. Prosecutor Ms. Carr arm M and unflinching. She laid out the evidence, the drugs, the scales, the codefendant situation, and emphasized that Pruitt hadn't been fully compliant on bond. While he'd passed tests, he hadn't engaged in counseling or provided proof of it. Her argument against a personal bond was crisp and direct, painting Pruitt as both a danger to the community and a flight risk. She even floated the idea of increasing bond beyond the $100,000 already set. Judge Wiggins took it all in an S-measured style, broke it down. He acknowledged the risk factors, the large quantities of meth and fentanyl, the prior failures to appear, the lack of stable housing, and the defendant's own admission of ongoing issues with meth. The conclusion was clear. He denied the defense's request, kept the bond at $100,000, and tacked on conditions. No illegal controlled substances, random testing, GPS tether if bonded out, and of course, no new offenses. In the probation violation files, he ordered Pruitt remanded until contested hearings could be held. The atmosphere of the hearing was calm but heavy. The attorneys were professional, the defendant stayed respectful, and Judge Wiggins kept control of the courtroom without a hint of impatience. There was no shouting, no chaos, just the slow weight of serious charges landing on the record. Wiggins' style here was exactly what the situation called for: firm, fair, and thorough, making sure Pruitt knew the gravity of what he was facing while keeping the process orderly and clear. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.